and Nyaya Mitra is well known for conducting classes for junior civil judges for the aspirants. Last several years we are conducting the classes. There is some gap between this during this period. Anyhow, now we are reviving our classes with our prestigious speaker. On this occasion, I have to express my sincere thanks to our Kakinada Bar Association and its president, Sri Eluri Subramanian garu. You know that Kakinada Bar Association is doing very good service on the guidance and leadership of President Sri Eluri Subramanian garu. Practicing since last 40 years, and he is a well-known criminal lawyer around the area. So he is contributing much more to our junior advocates and advocates fraternity with the help of Rama Reddy garu, Subramanian garu. So Nyaya Mitra, and on behalf of you also, I am expressing my sincere thanks to President Elur Subramanian garu and their team. Now I welcome Elur Subramanian garu to speak some forwards on this occasion. At the same time, I'm welcoming our speaker of this day, Sri Muzaffar Iqbal Khan garu. He is advocate practicing the Supreme Court as well as he retired means voluntary retired. He took voluntary retirement from service as a district judge. Who is having very good expertise in criminal law and all appreciation of students as he worked as a judge. So I'm very happy to introduce Sri Muzaffar Iqbal Khan garu from Jammu and Kashmir. In fact, it is very happy to us to see a speaker from that far area, and it's a very beautiful area. Now I welcome to say Subramanian Elur Subramanian garu speak on this occasion. Later again I will introduce Muzaffar Iqbal Khan garu. Thank you.
Listen, sir, please, sir.
Okay, thank you, sir. Thank you. First of all, I am very much thankful to the Mr. Rama Reddy garu and Nyaya Mitra Academy to conducting the Zoom meeting.
I love you. You like
Zoom meeting since 3 years prior. This concept was started during the course of pandemic and corona. The Rama Reddy garu and G. Subramanya approached me during time of corona and informed about their concept, because none of the advocates are coming to the courts. No one is practicing physical attending the courts. At that juncture, these two boys approached me, asked me about and informed about their concept. Then I am very much obliged. I am very much pleased. During that time, nobody is coming outside. Nobody is dared to do anything. Almost all of them are in a depression. All the advocates, 99% advocates. At that time, the Rama Reddy garu informed about the concept of the Zoom meeting and the legal affairs. Every since 2.5 years, every Friday at 6 p.m. they used to start each legal subjects, new subjects, and not only that, they have approached the several legal experts, judges, retired judges, famous advocates, and they have obtained their permission and took the appointment. So likewise, they started during time of 2020 June or July. After several episodes, number of advocates in all over Andhra, not only Andhra, Telangana, out of state also, me and appreciated the efforts taken by the Rama Reddy garu about the Zoom meeting. and in several places the same method is adopted and continuing. Anyhow, I wish you the Ramareddy Garu, and also I blessed the Nyay Mitra Academy to conduct these classes. It is very helpful to the legal fraternity. Not only juniors, even seniors also they can participate and they can learn something. So I am also congratulations the guest, retired District Judge Ibal Garu, and I am requesting you kindly cooperate and continue the same process, and God bless you. Okay, thank you, sir.
Thank you very much, sir. Suresh,
Thank
sir, please, sir.
Yes, thank you, President Garu, for your gesture of welcoming and blessings us. Now, without wasting our time, I will introduce our speaker, Sri Mujafar Iqbal Khan Garu. Already I told you that he is a retired district judge who took voluntary service from Jammu and Kashmir.
Suresh,
Thereafter,
sir, sorry for the interaction, sir.
sir,
I'm muting all, sir. Because we are getting disturbance, sir. Please, sir, please, sir. Please, sir, Suresh, sir, you can start.
yes. So, Khan Garu is a retired district judge, and now he's practicing in Supreme Court by taking high-profile cases. You know that recently I shifted my practice from Amravati High Court to Delhi Supreme Court. There we have been contacted, both of we acquaintance there. So immediately after I requesting, immediately after getting knowledge that he was retired district judge, I asked him, I requested him, sir, to take a class for our students. Immediately he accepted. For that, we are expressing my sincere thanks. So now I am requesting Sri Mujfar Iqbal Khan Garu, who hails from Jammu and Kashmir, please take the class. I think
Thank you, Mr. Suresh.
Yes, sir.
Am I audible to everybody?
Yes, sir, please.
Thank you, Mr. Suresh, and one senior member of the bar and the other colleagues which have joined me today. I'm grateful that you have given me this opportunity to share my experience. I'm not here to teach anybody because I'm still a student of law and at a learning stage. I can simply share my experience. And today's topic is a really very important topic, which is not only for assistance of those who are preparing for the civil services, but also for those who are judicial officers. It is a little bit complicated process. I think, can I start my video also? It is
Yes,
off,
sir.
I think.
Yes, sir. Start it, sir, please.
Okay. In fact, the magistrate trial in the criminal procedure code, if I'll give the language of each section, that will consume a lot of time. I do not want to waste my time in reading out the sections because they are available, but I'll give an overview that when a magistrate's job starts, there are, generally speaking, there are two kinds of magistrate trials. One is the warrant trial and other is the summons trial. In a warrant trial, again, there is a further bifurcation of the cases. One is on a police report, which is submitted under section 173 of the Criminal Procedure Code. And the other is otherwise than on police report, that may be on the basis of the information given by a complainant who directly approaches the court under section 200 of the CRPC. Then there is another case, another sort of the cases are kind of the cases, which is called summary trial. I'll come to that kind of the litigation in my later part of the lecture. So let me start first that at the initial stage, when a criminal charge sheet, that is after completion of the investigation, a charge sheet is presented before the magistrate and he takes cognizance under section 190 of the CRPC. Though that is not the beginning of the trial, but that is the cognizance stage. That is called, the magistrate is taking a cognizance under section 190. Immediately after taking cognizance, if he feels that it is triable by a magistrate, if it is presented to a chief judicial magistrate, in some states it is metropolitan magistrate, chief metropolitan magistrate, but all are magistrate class 1. If it is presented to a magistrate, the first and the foremost thing which he will see in the beginning is whether it is triable by a magistrate or it is triable by a sessions court. In case it is triable by a sessions court, after taking the cognizance, he will commit the same to the sessions judge. So that is the first duty after taking cognizance under section 190 CRPC. If it is triable by a magistrate, here again, the duty of the magistrate is, after presentation of the charge sheet, there is a provision in the CRPC under section 207. The first and the foremost thing which the magistrate has to see is that all the material submitted before a magistrate, either by the police or by the complainant, is to be provided to the accused. Along all the material means all the statements recorded by the investigating agency, whatever is presented under section 173 CRPC before a magistrate is to be provided to the accused. That is the statutory requirement of section 207 of the CRPC. After complying this, if it is on a police report, the magistrate will switch out to section 238 of the CRPC. Section 238, it enjoins a duty for providing every document that I have already talked to. After immediately accepting the charge sheet under section 173, the first stage where that is, you may say, the start of the trial, because the first and foremost duty of the magistrate is to see whether a charge is made out against the accused or not. If I may say so, this is the second critical stage in criminal jurisprudence. The first critical stage in a criminal jurisprudence is at the stage of lodging of the FIR by the SHO. And then in between, there are many stages, but the first critical stage in a court of law before a magistrate is the stage of 239 and 240 of the CRPC. 239, section 239 of the CRPC talks of when an accused is to be discharged. So I'll not read the language of section 239 CRPC at this stage because that will be wastage of the time. I'll see that what is the crux of section 239. The crux is the magistrate will apply his mind to the material submitted by the investigating agency, because it is the procedure for a trial to be started on the basis of a police report. So I will restrict my discussion only to the police report. In the subsequent sections, it also deals with the trial which is to be conducted on the basis of a private complaint submitted by a private person, that is otherwise than the police report. The term used is otherwise than the police report. So under section 239, it is a first very important stage of the trial. And you see that at this stage, the magistrate, who is a judicial officer, he will apply his mind to the entire material. To prima facie see that is there any material to frame a charge against the accused, a formal charge. And the requirement is that if prima facie, the magistrate is satisfied that yes, without questioning the credibility of the material, prima facie case is made out against the accused, he will frame a charge. So requirement of the charge is in a separate chapter. There is a separate provision dealing with it, which says that specific name of the offense which has been committed by the accused, time, place, and a description, small description that he may be aware of what are the offenses alleged against him, that will be framed by the court. Here, there is a confusion that what prima facie case means. In civil case, the prima facie word or the term prima facie has a different connotation. So far as the criminal trial is concerned, through a judicial pronouncement, the word prima facie for the purpose of framing charge has been interpreted by a judicial pronouncement and through the precedent till date. That first thing is that if the entire charge sheet or the entire evidences collected against the accused by the investigating agency, taken on its face value, without questioning the reliability or credibility, assuming that whatever is collected by the investigating officer during investigation is correct. And the magistrate is satisfied that yes, all the essential requirement of the alleged offense against the accused are satisfied, which in common legal parlance we call ingredients of the offenses are satisfied. It can be said that yes, prima facie, the accused has committed the offense, and magistrate will frame a charge against the accused if the grave suspicion. The second requirement is if the entire case of the prosecution falls in the category of a grave suspicion. Let me clarify it, that this grave suspicion is relevant only at the stage of the charge. And there's no need to confuse it that if there is a grave suspicion against the accused, we can convict him. No. If there is a grave suspicion against the accused at the initial stage when the charge is framed, the court is bound to frame the charge. If there's a mere suspicion, the court will be well within its right to discharge the accused. The trial will be terminated there. It is a very important stage for the reason that, as held by Honorable Supreme Court in 1979, a very celebrated judgment which has been followed till date until 2022. Recently, again, the Supreme Court has cited the same judgment, Praful Kumar's judgment, 1979 AIR Supreme Court. I hope it is 366. The broad contours of the powers of the court at the charge stage was considered by the Supreme Court, and that judgment assumed much importance for the reason that after the amendment of the CRPC in 1973, it was the first case under section 227 or 228 that reached up to the Supreme Court level. So in that judgment, After taking stock of all the previous judgment of the Privy Council, the Supreme Court finally came to the conclusion that, yes, if there is a possibility of conviction of the accused at the initial stage, after assuming that whatever is submitted by the investigating agency under Section 173 CRPC as correct, so charge is to be framed. If there is a grave suspicion, all the ingredients, then subsequent to that, there are 3-4 judgments, which has further explained what prima facie case is. So all those judgments, they have unequivocally relied on the judgment and has further explained that essential ingredients of the provision, penal provision, must be satisfied at the stage of the charge. And the most important thing is that at the stage of the framing of charge, the requirement of the section is that after giving an opportunity to the prosecution and the defense, after hearing them, you can either discharge the accused or frame a charge against the accused. So if the prima facie case is made out, the magistrate will frame a charge against the accused. If it is not made out, on the touchstone of the law laid down by the Supreme Court, if it is not framed, he will be well within his right, rather his duty bound to discharge the accused. If he is discharged, the case is closed. But let us assume that charge is framed, because we have to move further. What is the next stage? The next stage is the magistrate is required to put a question after framing the charge that whether he pleads guilty or not. And that question is to be put while framing the charge. If the accused pleads guilty, then under Section 241 CRPC, the magistrate may convict him. So he is not bound to convict, or he is not required under all probability that once the accused has admitted the charge sheet, the word is may, that he may further proceed with the trial or he may convict him. But that question is to be put to him, that if you plead guilty to the charge which has been framed against you, so if he pleads guilty, the magistrate may convict him under Section 241. But if he pleads not guilty, which in most of the cases happens, then he has to move further. Under Section 242 CRPC, he has to call upon the prosecution to produce the witnesses, to lead evidences in support of the charge sheet. So definitely the charge sheet under Section 173 is inclusion of all the materials, including the list of the witnesses. The prosecutor may make a motion calling upon the court to render assistance to procure the presence of some of the witnesses. So that in most of the cases has to be in the very beginning. The prosecutor may make a motion before the court, seeking assistance of the court for procuring the prosecution witnesses, some of the witnesses or all the witnesses. So witnesses are to be first led by the prosecution, because it is for the prosecution to open the case. If he does not need any assistance of the court, the prosecutor may on his own lead the evidences. After recording the statement of all the prosecution witnesses, and before calling the defense to lead the evidences, if the magistrate feels that yes, there is some incriminating material, against the accused during the trial. So trial begins after framing of the charge, not prior to the charge. The cognizant stage or any stage prior to framing of the charge, that is committal stage, is not a trial. So trial in a criminal case begins with the framing of the charge. So if in the course of the trial, the magistrate is of the opinion that yes, there is an incriminating material, something which requires an explanation, he'll put to the accused, seeking an explanation. And at the same time, he'll call upon the accused if he wants to lead the defense evidences. If the accused chooses to lead the defense evidences, he'll be given an opportunity to lead the defense evidences. So again, the same procedure will be followed. They'll be allowed to cross-examine. They will be allowed to be examined, cross-examined by the prosecution, because defense witnesses will be cross-examined by the prosecution. And finally, the trial concludes. And he'll pronounce his judgment of guilt or acquittal after the trial. That is in case of a trial on the basis of a police report. In case, if it is otherwise than the police report. So that comes the next, section 244. Section 244 deals with a case which is otherwise than police report. Otherwise than police report may be on the basis of an information under section, if we see section 190 CRPC, it says that there are three types of informations. One is police report, other is private complaint. Some private person submit a complaint where the magistrate takes cognizance. The third is on his personal information. If the magistrate has a personal information on his personal knowledge, he may take the cognizance also, some commission of the offenses in his knowledge. But in that case, there is subsequent provision that he has to give an option to the accused that if he wants to be tried by some other magistrate. So in case which is otherwise than a police report, and it happens to be a warrant trial, it starts with section 244. So section 244, it says that when the accused is brought or appears before the court, the trial begins. It is not that under section 190, when you take the cognizance, or under section 200, when you issue the process, the trial do not begin. The trial begins after issuing the process, when the accused appear before the court. And here again, there are two types of opportunities given to the accused as well as to the defense. First is before this trial begins. At the initial stage under section 200, the magistrate, if he takes the cognizance himself, he records the preliminary state for ascertaining whether, so that is, again, that is not the trial. That is just to ascertain if there is a material to proceed further, to issue process, calling upon the accused to be present in the court or not. Sometimes we see that under section 202, the process is dispensed with and further inquiry is ordered, but that is not the trial. Trial will be if process is issued, and accused appeared before the court. Hello. 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 Hello.
Yes, sir. We are getting your voice, sir. Please.
Okay. There was some disturbance, I hope.
Yes, sir. I muted, sir.
Okay. So the trial will begin when the accused appears. The magistrate will start his hearing the prosecution. Here the prosecution will be either the private party or anybody. If the prosecutor will, with the permission of the court, may also step into the shoe of the complainant, but mostly here the prosecutor is the complainant, the counsel of the complainant who has filed the complaint. So here he will first hear the prosecution and take all such further evidences that may be produced by the prosecutor. Here the prosecutor would be the complainant lawyer. Then magistrate, on the application of the prosecution also, that is the complainant's application, may direct some witnesses which the prosecution want to examine to be appear in the court, present themselves in the court. Then after that, again the same application of mind, which under section 239, the same application of mind is required under section 245 also. Again, for framing the charge, after appearance of the accused and after recording the statement which the complainant may wish to produce, that is the prosecutor here, the court will form an opinion that yes, a prima facie case, applying the same touchstone which was to be applied for the police report. Here, the statement recorded by the magistrate under section 244 of the CRPC. And after reading out the complaint of the complainant, if he is satisfied that yes, a prima facie case for commission of certain offenses is made out, he will frame the charge under section 246. And if he is satisfied that yes, no offense is made out, he will discharge the accused under section 245. After framing the charge, if the accused pleads not guilty, he will be permitted to choose the witnesses whom he wants to cross-examine, because some of them has already been recorded by the magistrate, not by the police. If he wanted to cross-examine any of the witnesses, it is the right of the accused to make a motion that yes, he wants to examine such and such, cross-examine such and such witnesses. After such cross-examination, again the complainant, who is the prosecutor here, will be permitted to lead further evidences, and they will also be subjected to the cross-examination. After this procedure is complete, that is, the prosecutor witnesses are recorded, they have been subjected to cross-examination by the defense. If the incriminating material is there, it will be put to the accused for explanation. And again, the defense witnesses, he will be allowed to lead the defense evidences under section 247. And after recording the defense witnesses, the case will be examined. And finally, the judgment of acquittal or conviction under section 248 of the CRPC will be pronounced. So this is the warrant trial by a magistrate under CRPC. There is another kind of trial, slightly different from the warrant trial, that is the summons trial. And it is important to note that all those offenses which carries punishment more than 2 years are to be tried as a warrant case, and which carries punishment less than 2 years will be tried as summons cases. So in summon trials, it begins with the provisions of section 251 CRPC. The summon cases starts with the when any complaint or because in summon cases, you won't have that formal framing of the charge is not required. It is the accusation of the prosecution or accusation of the charges are to be read over and explained to the accused. The trial will begin in the summons trial with the reading out of these charges, the substance of the charge, not to the entire charge, but the substance of the charge is to be read over and explained to the accused that this is the allegation against you. And we are going to try you for this particular offense, explaining the nature of the offense he has committed, time and place of the offense he has committed. And again, in this case, the judge will put a question that if he pleads guilty, rather there is a requirement of the section itself. If I may read it out, it is the requirement here. I'll read the relevant lines. The offense which he is accused shall be stated to him, and he shall be asked whether he pleads guilty or he has any defense to make, but it shall not be necessary to frame a formal charge. So it is the requirement by a magistrate in a summons trial to ask him that whether he pleads guilty or not. So that is the statutory requirement. Statutory requirement, rather an obligation of the magistrate to ask him whether he pleads guilty or not. So if he pleads guilty, the magistrate again may convict him on the plea of guilt under section 252 CRPC. And section 253 says that in petty cases, even in absence of the accused, if somebody else, for example, an advocate is pleading guilty, he may be convicted also in petty offenses. So the petty offenses are explained. The trial will begin when the further trial will proceed only if he pleads not guilty. If he pleads not guilty under section 251. So the only difference in a summons trial and in a warrant trial is that you have option to discharge the accused in a warrant trial. But in summon trials, you need not to frame a formal charge. If he do not pleads guilty, if he says that I have not committed any offense, and if he chooses to be tried, you will proceed further and you will say that, okay, the prosecution will lead the evidences. That procedure is prescribed under section 254. If he is not convicted under section 252, that is on the plea of guilt. The prosecution shall be called upon to produce the evidences. And again, on the application of the prosecution, the court may issue summons to the witnesses to appear before the court and record their statement about the commission of the offense. Then section 255, again, after giving an opportunity, the same procedure will follow. The accusation will be read over to the trial will begin with the accusation read over and explained to the accused, giving him an option to plead the guilty. Then if he pleads not guilty, calling upon the prosecution to lead evidences. Then incriminating material is to be put to the accused, calling upon the defense to lead their evidences, and then pronouncement of the judgment of acquittal or conviction of section 255. So this is the simple procedure for a summons trial in a criminal procedure code. So summons trial is little simple. Procedure is prescribed in section 251 to 259. Then there is an option given to the court that court may convert summons case into a warrant case where it thinks proper or fit that it may be tried as a summon case or it may be tried as a warrant case. So vice versa is not given here, but power is given to the court to convert a summons case into a warrant case. So this is all about the summons case, trial of a summon case, and warrant case we have discussed earlier also. So any question if anybody wants to ask on this?
Please unmute all and ask your doubts. One by one, there is a lot of disturbance. Please, Anusha, please ask. Or else raise your hand.
Somebody is asked, committal proceed.
Committal proceeding is different. It is under a different heading.
Yes.
Hello.
1 minute, sir. Somebody. Nagamani, please unmute. Nagamani, please mute it.
If she is not muted, you can do it now.
Yes, sir. I'm fixing for you.
She may not be knowing this thing. So
Yeah,
please do
muted.
it from your side.
Muted, sir. Muted.
So committal, somebody was asking me for the committal.
Yes, sir. Yes, sir. Please, sir. Please, sir. Please, sir.
Sir, Mujfar garu. Hello. Hello. Sir, Mujfar garu.
Hello.
Sir, all are practicing advocates, so there may not be any questions or doubts. Kindly further.
Sir, I have a doubt in regarding sureties.
Surety is a different topic. If you have any doubt about this summon trial, warrant trial, or trial by a magistrate, somebody was asking for the committal also, I can also explain. But surety will be a different topic. That is the entire chapter, different chapter. So I can give you a little bit of it because it will require a lot of time to explain everything.
Please explain about the committal procedure.
Committal is dealt with under a different provision, that is section 209. So after taking cognizance, I have explained it in the beginning of my lecture that after taking cognizance under section 190 CRPC, the first and the foremost duty of a magistrate is to see that if the offenses alleged against the accused person are triable by a magistrate, he will not commit the same. If it is triable exclusively by a court of session or any of the offense, any one of the offenses is triable by a court of session, he will commit the case after complying the requirement of section 207. Section 207 requires that he will provide to the accused the charge sheet submitted under section 170, the entire charge sheet. That is the statement of the witnesses, whatever evidences collected, recoveries made, effected, recovery memos, everything which is submitted under section 173, unless there are certain materials which are of sensitive nature and which cannot be provided, that too, after seeking permission from the court, that we cannot supply this material to the accused because of its sensitive nature. So after complying the requirement of section 207, under 209, the magistrate will pass a committal order sending the entire file along with the seized material to the court of session for its trial, because session trial cannot be conducted by a magistrate. So he has simply to take cognizance. Cognizance means he has to see by applying the mind that whether the case is triable by a magistrate or a court of session. So he will commit. Committal means it is a very recent judgment of 2014 says that committal is an executive process. It is not a judicial process because it is a bare formality. So in a committal case, you have simply to apply your mind to the extent that it is, if it is a magistrate trial or a sessions trial. If it is a sessions trial, you provide the entire charge sheet along with the material to the accused and pass a committal order sending the file, including the seized material, with a prior notice to the PP to the court of session.
Anusa, you can ask, please.
Good evening, sir. I have doubt about the IPC 302, sir. They have A1 to A10 accusers are there, sir. One of the person is absconded. What is the procedure by the magistrate, sir?
I could not get your question, ma'am. Can you repeat the question?
For example, I have taken the murder case 302.
Okay.
There are A1 to A10 accused are there, sir. One of the accused is absconded. What is the procedure done by the magistrate, sir?
Process, or he may commit the case with a general arrest warrant against the accused, which shall be published in the government gazette, sending it to the police head, that in case of arrest, he shall be produced before the sessions court. No, it is for the sessions court to frame a charge against the other accused who are present, keeping the trial against the absconder, because he will have to proceed under a specific provision. He may record the statement of the witnesses against the accused in his absence and may proceed with the trial. But that is the sessions trial. You need not to be concerned about that. But the magistrate job is that he will give a finding that the accused is absconding. He is satisfied that there is no probability of immediate arrest of the accused. So he will issue a general arrest warrant and committing the case to the sessions court. Hope I have cleared the. Hello.
Yes, sir. Yes, sir.
Hope I have cleared the question.
anybody,
Yes, sir.
please raise your hand.
Sir, what about the summary trial?
The summary trial again is a different procedure. Summary trial is dealt under section 260 CRPC. Summary trial, the only difference in a summary trial and a summons trial is that in a summary trial, only substance of the witness, statement of the witness is to be recorded. It is not the entire word by word verbatim recording of the statement of the witnesses is not required in a summary trial. That is the only difference. Rest procedure is all that is followed by as summon case. But in summary trial, only the substance of the statement of the witness is to be recorded. It is not the entire statement of the witness is to be recorded. That is the difference only. The rest procedure is same.
Sir, Kondada, sir, please. Kodanda, sir, please.
Good evening, sir. I want some clarification. Hello.
Sure.
In civil matters, there is chief advocates are filing for the witnesses. Civil matters. In civil matters,
yes,
chief affidavits of the witnesses are filing, but there is no provision in criminal cases. Everything has to be come from the mouth of the witness. I have observed in some courts, IO is the important witness for the prosecution and for the defense also. But the evidence of IO is not speaking anything, he is simply sitting on the chair, and the public prosecutor and the magistrate are recording the evidence. The public prosecutor is dictating the evidence, and the magistrate is recording the evidence.
That is
how
not
it will
permitted.
be stopped?
No, that
How
is not the
it is a
permissible.
leading evidence.
No, but
Then
that is
if it is like that, the defense will lose so many questions. How it will be stopped, sir?
friend, my dear friend, it is for the defense counsel to object it, because it is not the prosecutor. It is not the prosecutor who has to state anything said from the mouth of the prosecutor is not to be recorded. Whatever is said by the witness will be IO. So it has to come from the mouth of the IO only. If the clerical or the ministerial staff of the judge is writing anything which comes from the mouth of the prosecutor, that is not an evidence at all. That cannot be admissible, and the defense counsel is there to object it. He can say that he is not the witness. Moreover, he has got no business to lead the evidence. Prosecutor cannot lead the evidence. He can simply ask him to narrate the story. He cannot lead him. Defense counsel in cross-examination may lead, because that is his right. Under Evidence Act, he has got a right to lead the witness in cross-examination. He may lead it. He has a right to even ask the irrelevant question to the witnesses to shake the credibility of the witness. But this power or this right is not given to the prosecutor, because prosecutor has simply to ask him to narrate the story, and whatever comes from the mouth of the witness is to be recorded, not from whatever comes from the mouth of the prosecutor. That is not permissible under law. You can stop it, you can object it. No.
Okay.
Sir, anybody, sir, please.
Good evening, sir. This is Subhashni, Advocate Subhashni.
Good evening.
Good evening, sir. This is Advocate Subhashni.
Good evening. Good evening. Am I audible?
Yes, sir. You are audible. Sir, I would like to ask the same question which our senior colleague has asked you. Now, what happens generally? What's happening in the courts is that the IO of the case, criminal case, he's just opening the file, he's going through everything, and he's narrating the story in the witness chair. So in that situation, even if you object, being a defense lawyer, what if the judge doesn't listen to you? What is the remedy you have got?
Ma'am, in order to refresh his memory, the Evidence Act, I hope it is section 160 something. I forgot exactly the section. the Evidence Act gives that privilege to the prosecution witness that he may refresh the memory from the file. He can see it. So that is permissible. But IO is not an eyewitness. You cannot rely much on the IO. IO is there to clear the cobweb of doubts created by the defense. If the defense lawyer is vigilant and he is versed with the Evidence Act, he can create further doubt from the IO story. IO is a witness only to the site map. Very important witness. There is no doubt in it. I am not saying that IO is not an eyewitness, therefore he is not an important witness. He is a very important witness in the entire criminal jurisprudence. He occupies a very important position because he has seen with his own eye the site of the crime. He has prepared the site map, the recovery memos, which are all having a corroboratory value. But the most important thing is, it is the eyewitness or the circumstantial evidence. If there is no eyewitness, the other circumstantial evidences, the IO will relate and connect the story, his investigation, his map, his recoveries with the main witnesses. The main evidences are either the eyewitness or the circumstantial evidences other collected by the IO. So in order to refresh the memory, the law gives him that privilege. He can see the file and he can refresh the memory. But he cannot mug up the things from the file, see again and again and say that this is the position. So that you can object, but looking at the file, CD file, or even the court file or the prosecutor file by the IO is permissible.
Relevant provision is 159 Evidence Act.
Yes, 159. Yes.
Thank you, sir. And one more question, sir. Nowadays, there are lots of false cases, especially 498A, wherein, as you said, they may not be eyewitnesses. They may be circumstantial witnesses, which we may say hearsay also, sir. In that situation, when an IO wrongfully files a false case, intentionally files a wrong case, favoring the prosecution, favoring the de facto complainant, in any which ways, whatever may be the reasons, what is the best way to lead a defense, evidence, sir, in that case?
Ma'am, it varies from case to case because no straitjacket formula can be given. It depends upon the nature of the evidences. If the nature of the evidence is of a direct nature, you can contradict him. Defense witnesses to be led, one thing one must keep in mind, that before leading the defense evidence, you have to lay your foundation. For example, in a criminal case, when the incriminating material is put to the accused, is put to your client, at that stage, the lawyer must have in mind that what defense I have to take. So in accordance with the defense, he has to guide his client, the accused, to make statement under 313. If you are silent, you are simple, you are saying, I'm denying this. Everything is false. How will you lead your defense evidence? You will have to lay your foundation at that stage, at 313 stage. When accusation is put to your client, that how do you explain these are the incriminating material against you, these evidences, these witnesses has stated these things against you, what is your explanation? You will have to take a stand in that explanation. Only then leading defense evidence will be of any benefit for your client. Otherwise, it will be fire in the air. You have not laid foundation. So first, whenever you start your defense, while even class examination, when you put questions to the witness, you will have to lay the foundation of your defense at that stage from the beginning. Then your firm foundation will be 313 stage.
Yes.
I hope I have cleared the doubt.
Yes.
Sir, under which provision the magistrate will split up the case, sir?
So, excuse me, what do you want?
Under what provision the magistrate will split up the case?
Speed
When
up,
the accused is absconded.
Splitting, sir. Splitting the case.
splitting, that is a different chapter. Yeah, that is an entire chapter. Splitting, I could not understand which type of splitting do you mean?
Some of the accused are absconded. Or they are
315 or 315, I think, you please refer.
No, 315 is to open the defense evidence, sir. It is an application for.
No. Splitting, I could not follow. Suppose some of the accused persons are absconding.
Yes, sir.
Yes, sir.
There is no need of splitting. There is no need of splitting the trial. The trial will continue, and the provision is under CRPC. There is a provision because we are versed with the J&K CRPC. J&K CRPC is different.
Yes, sir.
So there is a provision in central CRPC also where you can record. Here we have 530, where the statements, the witnesses will be recorded in absence of the accused. The trial will continue. When they will be apprehended, the absconders will be apprehended, they will be produced. They may be given an option that if you want to cross-examine further, they will call back the witnesses and the trial will begin from that stage only for cross-examination. If they will say that, okay, we admit whatever has been stated in our absence, and the cross-examination conducted by the other accused persons is admitted to us, the judgment will be pronounced. So there is no need of splitting. The trial will continue.
Okay. Suresh, sir, let it complete, sir, please.
ఓకే క్లోజ్ చేసేద్దామా?
చేద్దాం సార్ ఇంకా ఎవరు
ఓకే థ్యాంక్ యూ సార్. స్పీకర్, we have to express our sincere thanks to our speaker, sir, because
one more doubt, sir. Venkataramanamma. Please ask them.
Sir, I have a little bit doubt about summons and warrants, sir. Can you explain me?
Already.
Summons and warrants, issuance of summons or warrants are warrant trial and summon trial. Is it issuance of summon or warrant trial and summon trial? What do you want?
Amma, me doubt trial meda issues meda summons issue చేయడం మీద వారెంట్ ఇష్యూ చేయడం మీద ట్రయల్ చేయడం వారెంట్ కేసు ట్రయల్ చేయాలి ట్రయల్ చేయడం క్లియర్ గా అడగండి.
Both, sir.
He's asking
Issue చేయడం మీద
issuing of summons and issuing of warrant.
Issuance of summon and issuance of warrant.
Yes, sir.
Normally, it is not that in warrant case we should not take it that in warrant case the warrant is to be issued, in summon case summons is to be issued. It has no link with it. In every case, if the accused is absent, first the Supreme Court has recently said that you issue in Satinder Kumar Antil's judgment 2020. I think last month judgment or last to last month. The Supreme Court has said that first issue summons. If he do not appear, then issue bailable warrants. If still he do not appear, then issue non-bailable warrants. So in every case, first we have to start with the summons, then with the bailable warrants, and subsequently the non-bailable warrants. If non-bailable warrants are issued, the accused may through counsel. Earlier, I was also under this impression before the judgment of the Supreme Court recently in Satinder Kumar Antil's judgment, that once the warrant is issued, it can be cancelled only on appearance of the accused. But the Supreme Court has said in this case that there is no need of appearance of the accused. he may make a motion through a counsel or through somebody else also, seeking cancellation of the warrant on the ground that he will appear on the next date of hearing. So summon trial and warrant trial has nothing to do with the issuance of the summon and warrant is totally different.
Please.
I hope done with the question.
Yes. Suresh sir, please go.
Okay, sir. Normally, we know that Supreme Court practicing advocates and retired judges are busy with their work. Despite of that busy work, Mr. Khan sir accepted our proposal invitation and delivered a very good lecture on section wise. For that, we have to express sincere thanks from our side. Thank you, sir. And
My
to-
pleasure, Sundar, my pleasure.
Thank you very much, sir. Thank you, one and all.
Thank you very much.
The meeting is concluded.